Okay, New Directions Housing Corp., DBA Special versus Kimberly Schlusher.
Craig Joyner here for the plaintiff judge.
Good afternoon, and Mr. Matlock's here for the defendant. You want to say?
Yeah, we're gonna have a pretrial motion to dismiss,
Okay.
Judge. I
All right.
believe you have copies of the notices that were given.
I do. I've got everything that Mr. Joyner sent over.
Should be Exhibit 8 and 10, Judge, are the two notices that were provided. Exhibit 8, Judge, is allegedly a second violation notice that was served upon my client allegedly on February 16th. Judge, if you want to take a minute, neither of these notices provide 14 days to cure on a lease violation. Furthermore, Judge, and I'll let you look at it.
Okay. Would you like me to go ahead and read 10?
You can, Judge.
Okay.
Exhibit 10 is actually the notice that is referenced on the complaint.
Okay. Okay.
So, Your Honor, I think this fails under Uralta because it does not provide a 14-day notice remedy to cure language. Judge, furthermore, on the notice that is referenced in the complaint, the Exhibit 10, March 6th notice, it says the client would have until April 30th, 2024. Now, I don't think this notice is proper based on what I just said, Judge, but if it were, it says the client has until April 30th, says 30 days from the date of this letter, but then underlines and boldens says you'll have until April 30th to vacate. And this case was filed on April 18th, Judge. So it's my understanding that that would be premature based on the notice. And furthermore, Judge, there is no 14-day to cure language in here. In fact, it makes reference to, on the March 6th notice, the second paragraph from the bottom, it's of the opinion that New Directions Housing Corporation, that this you cannot remedy this breach of lease. However, in their February 16th notice, Judge, it makes reference of these same issues saying that you need to stop this immediately. So I don't think we can have it both ways. It's clear 14-day notice under Uralta is required, notice to cure. If you're going to give a 30-day notice to a certain date, April 30th, you have to at least wait for that date to file. I think this case fails on both, Judge.
Mr. Joyner?
Yes, Judge. I don't think you can look at this in a vacuum. If you look at our exhibits, specifically starting with Exhibit 7 through 10, Ms. Schlusher had committed violations which can't be cured. She had continually denied New Directions and or their people that they've employed to do inspections and do pest control to come into the units. We can't cure things that are already passed. We sent her on February 16th, notice of breach for the second time. We also sent her notice letters about inspections. That's Exhibit 9. On March 6th, in compliance with the federal programs under which New Directions operates, they sent her a notice that she would have 30 days because they were terminating the lease. She made no efforts whatsoever to communicate or otherwise do anything to move or explain her activities. True, we did file the actual petition before the end of April, which we had indicated to her we were going to wait to that date, but it was more than 30 days after the March 6th notice letter. So we believe we're in substantial compliance of all notice requirements. The defendant did nothing to respond to any of our requests, reasonable requests, that she either change her positions, permit them to have access, stop being harassing to the employees and to the service companies that were trying to treat the unit. And therefore, based upon her failure to do anything reasonable, the plaintiff decided it was in everyone's best interest to file this action, which was filed, I believe, on April the 16th or 18th. I can't remember off the top of my head. But we believe that all notice requirements have been substantially complied with, and that this case judgment needs to be entered.
Well, Mr. Joyner, had you waited 12 more days to file, I would agree with you. But when you send a tenant notice that specifically says, and I quote, your lease will be terminated 30 days from the date of this letter, April 30th, 2024, which agreed is more than 30 days, but you specifically bold and underline the date. If you have not vacated your apartment by that date, a court order will be sought for eviction. So you specifically gave her the date of April 30th to be out, and then yet you filed this petition before that date. So legally, April 30th was the right date because you sent that letter March 6th. I don't know why you didn't take action before then with the previous notices, but you didn't. You gave her till April 30th, but you filed before then. So I think Mr. Matlock is right. This is improper and this case is going to be dismissed.
Yeah. Okay. Go.
Hand me my screen box. Now no freak.
Larry Refresh Landing Revocable Trust versus unknown occupants, or AKA squatters of 7601 Shepherdsville Road. Hi.
Hello. Good afternoon, Judge.
How are you?
I'm good.
Judge Andrews A for the plaintiff.
Okay, and tell me your name.
Larry Holden.
And what is your relationship to this case, Mr. Holden?
I am being called a squatter.
Okay, all right. So you're currently living at.
Yes.
Okay,
And Judge, I should have Juan Jewel on as a witness.
okay. Mr. Jewell, would you please unmute? There you go. Would you please raise your right hand? Do you swear or affirm the testimony you're about to give will be nothing but the truth?
Yes, ma'am.
Okay, thank you.
Juan, what's your relationship to this property at 7?
With the trustee.
The trustee of a trust, the trust owns the property, correct?
Yes.
Yeah, okay, and you're the trustee of the Rellery Refreshed Landings Revocable Trust.
Yes.
And when did the trust acquire that property? Or actually, Judge, I should have asked ahead of time if I could have permission to screen share. Okay, Juan, can you see my screen here?
Yes.
Okay. And do you recognize this document?
Yes.
Okay, and I'll scroll down here to the signatures. It appears to be a deed signed by a Dustin Pittman, administrator, as the grantor, and I believe down here it says J. Jewell, trustee. Is that your signature?
Yes.
Okay. And it appears down here you signed it on March 12th, 2024.
Yes.
Okay. At the time of this, I'm sorry, who is Dustin Pittman? Other
The
than
owner of 7601.
he was the owner of the property that conveyed it to the trust?
Yes.
Okay. And that was for an estate, correct?
Yes.
Okay. Let me go on down here, jumping around. And attached to this deed appears to be an order signed by Judge Katie King from the Jefferson District Court Probate Division, granting Dustin Pittman the authority to sell that real estate, correct?
Yes.
When you acquired this property, or the trust acquired this property in March, to the best of your knowledge, was anyone living in the property?
No, not to my knowledge, no.
Okay. Did you enter after purchasing the property? Did you enter the property and inspect it?
Yeah.
Okay. Did you find any evidence of someone residing there?
No, I didn't. I
Okay.
seen items.
You saw personal property left behind?
Yes.
Okay. And you understood at that time that it was the house was owned by the decedent of an estate, correct?
Yes. I assume
Okay.
so, yes.
And then how do you know the defendant? Now the defendant's the squatters and trespassers, but Mr. Larry Holden has appeared in court today as the defendant. How do you know him?
I had met him at a previous property that I was working on, and he approached me about said property.
Okay. And
Yeah.
you were working with him at a previous property, so you had previous contacts with him. You knew who he was.
Yeah, I was working on another property in a different area of the town, probably up the street. And he had approached me about the house that I was working on. And we began to talk from there. And I believe I had asked him, do you have any other properties for sale? And he said, yes, he did. and he was talking about 70.
So
I
he,
swear the zip code.
so prior to this conveyance, this deed we just looked at, you had communications with Mr. Holden about him selling you this property.
Yes,
Okay. And did you all ever come to an agreement or enter a contract?
we did not come enter a contract at all. No,
Okay.
but I did send him an offer.
So how did you then come into contact with the administrator of the estate, Dustin Pittman?
He had gave me a phone call
Okay.
and just said he had a house he wanted to sell.
I'm sorry to interrupt, but do you typically receive phone calls like this?
Yeah, maybe 6, 7 a week.
Okay. Do people know you to be someone who buys houses?
Yes,
Okay.
yes,
So you don't know how Dustin Pittman came to know you, but
no,
he called you. He somehow came to know who you are.
yes,
Okay. So he contacted you on behalf of the estate and offered to sell you this house?
yes,
Okay. Did you, and as we saw in that deed, I guess the trust you represent as trustee elected to buy the house from the estate.
yes,
What then, in that case, you've testified that it didn't appear anyone was living in that house at the time you acquired the property. You had no knowledge of anyone occupying it or living there. What happened that made you realize you needed to file a forcible detainer action?
I had went by one day and Larry was there, and we were talking about somebody had changed the locks, and I was like, oh well, okay. He looked up online and seen that the property was transferred, and I was the trustee, and he had took the locks out, and we switched them back,
Okay.
and from there we leave, or I left or whatnot. I switched the locks back. We left. Then he gave me a phone call like later on, maybe that day or the next day, and he said, "Hey, this property was stolen from me, and the deed that you signed is illegal."
Okay.
So
So you said you came to the property and Larry was there. You knew Larry from prior
yes,
interactions.
yes.
Did he say why he was at this property at that time when you met him?
I don't recall. No.
Okay. But then he, at some point later, soon thereafter, asserted some sort of possessory or ownership interest.
Yes.
Okay. And since then, has he entered the property?
Yes. He had called and told me that he was going to enter the property, and take possession of the property, and he's not going to leave unless somebody drags him out.
Sure.
And I said it's it's not
So,
going to come to that.
so you decide to file a forcible detainer action because Mr. Holden is asserting an ownership or possessory interest over the property and has in fact entered since you've owned it in March.
Since the trust has owned it, yes, I'm not the
Yes,
owner.
I'm sorry. Thank you. Since the trust is owned. Okay. I'm sure we'll hear from Mr. Holden in a moment, but you, to the best of your knowledge, Mr. Holden is still asserting some sort of right to possess that property, correct?
Yes, as far as I know.
Okay. Judge, that's all I have for right now. I'll reserve the right to redirect.
Okay. Mr. Holden, at this point, if you have any questions for Mr. Jewell, now is the time to ask them.
Okay, great. One is, I don't know how to do this formally. I'm not an attorney.
Okay, yeah.
So, one is kind of told part of what,
Hold on. Do you have any questions for him?
will I have an opportunity in a moment to ask a question?
No, now is the time to
Now is
ask
the time.
questions. So that's why if you want to testify now, I need to make sure that Mr. Zay is finished with his case and then I need to swear you in.
Okay, yes,
Mr. Zay, do you have any other witnesses?
Judge, this is my only witness.
Okay. Do you want to testify?
I do,
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be nothing but the truth?
Yes, ma'am.
Okay, go right ahead.
This property was, owned by Jack Pittman, passed away. His son was Dustin Pittman. He left more than one, parcel of real estate in Jefferson County. The heir, Dustin, did not know what to do. Properties were free and clear, but he had no idea what to do to transfer them or sell them. So my partner and I discussed with Mr. Pittman and other members of his family that we would take on the burden of maintaining both of the properties in Jefferson County, as well as hiring attorneys to handle the probate process. And also in that agreement, we would be purchasing. I have here a contract for that is filed in probate court, along with that order that you have. That order is probably pursuant to this contract.
What
And-
order are you talking about?
The order that is with the deed that we viewed on the screen share
Okay,
from Mr. Zay moments ago.
okay,
Mr. Jewell did make, well, I say an offer, he made 4 offers to us. He made 3 offers last year. We had some negotiation with him, and we did not select him to purchase the property from us or purchase our purchase contract. I talked with him again in February of this year, where we discussed purchasing the contract for. That was in February. I have a spreadsheet that has every phone call and text message and voicemail that I've had with Mr. Jewell since last year. When Mr. Jewell closed this property, he used closing attorney Borders here in town. In order for him to use that order, he told John Borders, who's one of the principals of Borders, that he did not really know me and that he had spoken to me sometime in 2023. That was the last he had heard from me, and he didn't know anything else about me. I have proof, emails and voicemails from Juan where he has made offers to us as recently as February of 2024. Since that time, he has called the police department and told them that there's trespassers there. He doesn't know who they are. They've come to the house. I've shown them the probate file, our documents. We've had 3 separate attorneys working on this since the inception of the contract, which was last year.
was the contract after the elder Mr. Pittman had passed away?
Yes, there were 2 contracts. One was initially with Dustin and our company, and then our closing attorney, Chuck Crosby, said that that was improper and that we needed to redo the contract so that it was from the estate to us. And we did that because that's what our attorney advised. So, and actually the contract is still in force to this day. Mr. Jewell has, and I have proof of this, has offered us tens of thousands of dollars to, he offered us $20,000. Another time he offered us $30,000, and then his final offer was $45,000. And then after we rejected that $45,000 offer, that next day is when he sent the Louisville Metro Police to the house. So my point in saying this is he misrepresented to the closing attorney that he was aware of the active contract. Anytime Mr. Jewell was in that house, he was in there because I let him in. We've had the keys and possession of the property since last year. I have utility bills. At this point, he has also turned off the utilities at that property. He had LG&E come out and disconnect the electricity at the pole.
May I see the contract?
Yes, ma'am.
The sheriff will get it from you.
And Judge, Mr. Holden has previously presented me with copies of those contracts,
Okay,
and I don't have any objection. I think that they prove, I would just say that I think they prove an issue that's not before this court.
right.
That's
That's,
the contract.
That's where I was going. I just,
When you're done, I'll continue, Judge.
what was the date that, Dustin Pittman was made? Do we know, Mr. Zay, when Dustin Pittman was made, executor of the estate?
Judge, I believe he was appointed sometime in winter or spring of 2023, if I recall. I'm not sure though, Judge, because he's not a party to this.
Yeah, okay. Everything that you stated, may be 100% valid, but it's not for this court.
I understand that. At this point, we are preparing a quiet title for circuit court. I discussed it with Attorney Curry Butler late last week, and I have been in contact with Kevin Ford's office just today.
Okay,
So that's where we stand on that.
thank you.
Judge, I want to allow Mr. Holden to finish his evidence, but I'm prepared to make a closing, I think, on this.
Okay. Is there anything else you want to tell me, sir?
There's a lot, but I don't know what's relevant, and I don't want to waste the court's time.
Well, I mean, it sounds like you know what you need to do as far as taking the legal action. It's completely separate from this.
Yes,
Okay,
and
so-
I would ask that the court give us time to have this sorted out in the proper way. There's more at stake here than just this property. There's another piece of property that Mr. Jewell transferred.
I can't talk about another piece of property that's not before me, sir.
Yes, ma'am.
So,
I apologize.
okay, that's all right. Mr. Zay?
Judge, I would say that their parties may have liability to one another in some respect, but I think we presented that Mr. Jewell's the trustee and the signatory on the deed for the property in March. They own the property. There's been no lease agreement presented. There's been, essentially, from all legal standpoints, the trust has the right to exclusively possess the property. I don't know why the trust elected to pursue against squatters and trespassers rather than Mr. Holden by name, probably because there was no lease and they did not know who else is there or who else is trying to take possession. So I think Mr. Holden's issues may be more properly addressed in a different court, but for this court's purposes, my client has the right to possession of the property for the time being at least.
Do you want to say anything else in closing?
Yes, ma'am. I think that I think I've demonstrated that Mr. Jewell acquired the property outside the bounds of the law.
That's not what I determined in this case.
I
Okay?
understand.
I determined who has the legal authority to be in the property. Okay, and in this case, I am determining that the trust does have the right to be in the property. Now, that does not mean that you don't have an ownership interest in this property. That's what circuit court will determine. Okay, but that's not what I determined here. Okay, if there was fraud, if you have an ownership, if whatever those things that need to be determined will be determined in circuit court. Okay.
I understand that part, but what my statement that I'm making is that should the court recognize their deed just because they signed it, if it's not proper, if they obtained it criminally, then how is
I
it?
can't determine that, sir. I have a lane that I need to stick to,
Yes,
and that is not in my lane. Okay, that's far outside of my lane. That's what circuit court will determine.
no, I don't want you to determine whether or not they obtained it illegally, but if I can prove that if it's not a legal document, it appears that it's not legal,
Mhm.
then wouldn't it be unjust to give someone something that they are not entitled to just because they come in and say, hey, it's mine, and give you a piece of, say, hey, it's mine.
Well-
Even though they coerced, or let's say that, for example, can I give an example?
No, we're not talking in
Hypothetical.
hypotheticals.
Okay, but
I understand what you're saying, and yes, things that are wrong happen all the time, okay? But the very first thing that you told me was that you signed a contract with someone who didn't have authority to sign a contract. So nobody is quite above board on anything in this one, I'm thinking.
No,
So-
no, ma'am. I have a contract with the executor of the.
I understand, but the
with the
very first
administrator
one-
of the
I'm
estate.
not arguing with you, sir. My decision is made. Thank you.
Thank you.
Thank you, Judge.
LREI versus Maureen O'Connor. You can have a seat or one of these tables, ma'am, whichever one they're not sitting in. I'm going to ask you to please raise your right hand. Do you swear or affirm the testimony you're about to give will be nothing but the truth?
Yes, ma'am.
Okay.
All right, Crystal, can you state your name for the record, please?
Crystal Sotomayor.
And you're the manager for LREI,
Yes,
and you all manage the property at 30.
yes, we do.
And Maureen O'Connor's a tenant of yours at that address.
Yes, she is.
On or about April 2nd this year, did you all send a 14-day notice of lease violations for, among other items, failure to maintain the property and disturbing the peace and quiet enjoyment of others?
Yes, we did it.
Were the violations cured within the 14 days provided? Have you all accepted any rent from this tenant since the filing of this petition? Are they still in possession of the property?
Yes.
And when did you all last check to see if they were in possession?
Last week.
All right, I'm going to show you some documents here, Crystal, and then the deputy, I'm sorry, I forgot to make a copy so that he can show them to Miss O'Connor and to the judge.
It's okay.
First document I have is a copy of the notice letter here. Crystal, are you familiar with this document?
Yes, I am.
Is it a true and accurate copy of the notice that would have been sent to the tenant?
Yes, it is.
And here on the back of the page is the certified mail receipt for this
Yes, it is.
document. And this document goes on to discuss violations such as improper trash disposal, good neighbor, which is disturbing the quiet use and enjoyment of others, and unlawful use of the premises. Is that correct?
Yes, it is.
The next document I have for you, Crystal, because no Judge Lipsy wouldn't let you go without it, is the lease agreement. Is this a true and accurate copy of the lease agreement?
Yes, it is.
And does it set forth all the terms and conditions between the parties, including proper use and the permits, disposal of trash and expected behaviors?
Yes, it does.
All right. Crystal, can you describe to the court the type of violations and what's occurring at the property?
Miss O'Connor has been having trash out on the patio area where the actual owner of the building does not allow that. Have the trash up, keeps rodents and stuff out, but she had a pest control issue also. The good neighbor, it comes from a lot of the residents that live there. These are considered like individual condos for each one. So the residents and the building manager has been complaining and getting a lot of complaints on here because to saying that, and I'm not saying that it's true, but just that I noticed that she's been drinking, and when she gets intoxicated, she's being real loud, knocking on people, cussing people out. Just being really loud out there on the property, and they're tired of it, and she's getting a bunch of complaints.
As from my understanding, there's also, there's improper disposal of the trash. Is there trash being left out?
It's been left out on the patio area, which we have the picture right there.
And is there some form of a shopping cart that's managed to make its way up to the second floor there?
Yeah.
And some patio chairs?
The chairs are okay, but it was, I think it was so many of them, I think, because it's
Okay.
hard to walk fast.
All right. And Crystal, are these violations still ongoing to this next day?
Yes, they are.
And y'all are still receiving complaints about disturbing the neighbors?
Yes, we are.
And are they on the call?
Yes.
All right. And looks, according to Ms. Crystal, we have two witnesses on the Zoom calls to testify to these as well, Your Honor.
Okay.
So we would tender Crystal for cross-examination.
Okay. Ma'am, do you have any questions of Ms. Stoudemire at this point?
First of all, I went to legal aid.
Okay, hold on. My,
Well,
now is
do
the
I
time
have
for.
questions? Yes.
Okay, ask the questions now.
Okay, I would like to know why I was not notified of, when you got these complaints. I want to know why I wasn't notified before you wrote up an eviction letter of what the story was. I had no idea that I was getting these complaints, except I heard that I've been evicted, that I was being evicted by some of the neighbors that I had not even heard from them. I had not even received anything.
Ms. Murray, I talked to you personally myself.
This was after, when I called you, I called you after I got the eviction
I know, you
notice.
didn't let me finish, so, I talked to you personally myself in regards to your violation that you had, and you told me you was gonna correct it, and you kinda got upset.
Which violation are you talking
The
about?
one that you was fussing and cussing, and I asked you, was you drinking and.
I don't drink. I do not
That's
drink.
what you told me?
I do not, I never said I drank.
And I didn't say that you
Okay.
did. I said that's what you told me.
I haven't drank
Ma'am,
for 25 years.
If you're gonna testify, I have to swear you in. Right now, you're only supposed to be asking Ms. Stogmeyer questions.
Okay, okay. Uh-huh.
Would you like me?
Do you swear or affirm the testimony you're about to give will be nothing but the truth?
Yes,
Okay. What do you want to say?
I don't drink, and I never said I drank.
Okay.
As far as complaints with others, I have never seen such a wild place in all my life. There are constant stuff going on. I have been assaulted on the balcony where I am.
Objection.
And I have had lots of neighbors that bother me that way, but not physical. That one was physical. But I admit I do defend myself, not physically. I have verbally defended myself, and that is what. And you said that I agreed that it would stop. I can't stop these people from. I never said that I would not. Say something back to them. I never agreed to that. So I will continue to say stuff back to them when I'm verbally attacked or physically. And the other violations. The trash on the deck there, the balcony thing, that is taken down. I take that down right down to the dumpster. It's not like I leave trash sitting out in front of my place on a regular basis. That's not my style. I take it out, put it there when I'm cleaning my place. I put the bag out there and I take it down. A lot of people do that. Okay, the other violation. What else was there? I can't remember what else you said.
She wants to know what I said.
Failure to maintain, disturbing the peace and quiet enjoyment of the property.
Okay, I think I covered all of that. These are, I do want to ask this. Why am I getting evictions without being spoken to before these letters get to me, say eviction for prostitution? For God's sake, what did they do? Call you up and you just say, okay, well, yeah, she's a prostitute. Okay, police violation. I'm sending you a letter. This is stressful to me. I don't get any, first of all, I don't get a call saying, there's been a complaint. This person's saying this to you. And what do you say back to that warning? I never get that. I get letters in the mail and they're stressful. I want out of that place and I plan to be out of that place.
Okay,
But I want,
Can we give her some days to move?
I need a Section 8 voucher first. I can't apply for places. And I need recommendation from them that I didn't do anything. I do need this court right there. That I don't want an eviction on my record.
Well, then, if you don't want an eviction on your record, let's see if we can come up with an agreement.
I can offer the week to vacate, Your Honor.
They're willing to offer you 1 week to vacate, ma'am, and if you're out, this will be dismissed and you won't have an eviction on your.
I can't say that the voucher has not, I have not yet received it. I've applied for it. I've called 2 administrators, waiting for that.
Ma'am, let me
Yeah.
make it clear. The other option is you have an eviction today.
Eviction today. No, then I'll take the 7 days, did you say?
Uh-huh.
Okay, that's fine.
All right, we'll continue this till July 1st at 11 a.m. If you have moved out and returned the keys, then this will be dismissed against you and you will not have an eviction on your record.
Okay.
Okay? Thank you. Nancy Allen versus Tremaine Carr.
I'm here, Your Honor.
Okay. I'm going to start with Ms. Carr first. Ms. Allen first. Okay, would you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be nothing but the truth?
Yes.
Okay, what would you like to tell me, ma'am?
I just would like brother to vacate, not sleep in my driveway or be in my yard when I'm not home.
Okay,
He appears to have gotten all his stuff, but I won't know for sure for a couple of days.
where Where was his stuff that you think he's gotten?
It was in my den,
In your what?
in my den, in the.
Oh,
den.
okay, okay. So it was inside the home.
It was.
Okay,
yes.
but now you think it's all gone?
I think so.
Okay,
It was, some packages, I would say, in the corner,
mhm.
and I wasn't sure if any of those things belong here for me. Cause I am doing a lot of remodeling right now.
Okay,
But I think that, 3 days turned into this. I don't know anything about it.
how long ago was it that you allowed
It
the
was
3 days?
January 18th, my birthday. I decided to be nice
Okay,
and let him come stay. Remember with the bad smell in January. And, basically, I don't want any money or anything. I've done my part.
okay. Mr. Carr, please raise your right hand. Do you swear or affirm the testimony you're about to give will be nothing but the truth?
Yes, sir. Yes, ma'am.
Okay. What would you like to say?
We had an arrangement on me staying. We never did do a lease or anything like that. When I moved into the premises, we did just a verbal agreement to pay $200 each week and to help her out around the house as much as I can. I had worked on other houses prior to renovating, and I do yard work. So I started out doing that. I paid for the renovation stuff that I had to. It was basically the electrical and the outlets and stuff in the house. So when I started out doing that, I bought all the stuff and I put the stuff in, and I also gave her the $200 that we had agreed on each month. At the beginning of that month, at the beginning of February, that's when I gave her that. And we had arranged, and we went out to the store, to the Lowe's together, and we bought this stuff together. I paid my part for the electrical, and she paid for a tarp that she wanted put on the house because the roof was leaking. So I went in and did all of that work, and about a month after that, a guy came over to the house that used to stay at the house. He was looking for some of his shoes and stuff he couldn't find. They accused me of stealing it. She told me, next month you need to get out and leave. So the next month passed, and I paid her again, and I had already finished all the renovation stuff. I started into the next renovation, basically spackling the walls, filling out holes and stuff that was in her house. So I did all of that. At the end of that month, she was like, I'm going to call the police if you don't leave. So when she called the police, I showed the police my proof at the end of that month, and they told her she had to file an eviction for me to be put out because I had been paying her and I had the proof to pay her, and she had told them that I paid her as well. So we come to this part of it when I got a voucher. I'm full disabled, and I got a Section 8 voucher granted through Section 8, and she knew about that. That was started on April. She filed the eviction to basically, have me with an eviction on my record, because when you're going into apartments looking for apartments, they're checking the eviction record. So she did that with my mother told her to do that. And then that would be the fastest way to get him forced out of the house, which is fine. But she took payment from me, and we've been living off my food stamp card and the remainder of her food stamp card all month and every day. So I understand that they are filing the eviction. I understand that. So I took all my belongings, which was one bag of clothing, out of her den. That's all I had at her house ever. I had 3 plants and 1 bag of clothing. So I took the plants and the clothing away from the premises and left, and hadn't been there, last night or the night before. So she, knew that I was going out of the premises or whatever, because I had talked with a judge, but they never even served me an order. She came in and threw an order down the other day and said that I was supposed to come to an eviction court. I never even got served an order. So I really didn't know if it was legal process or it was, you know, due diligence or that's how they do or whatever. But that's what I was saying to the court kind of last time. I didn't really get any kind of notice or anything, and I had paid her and done work for her in her property. And I understand if she decides to renovate the property, but if you have a person work on your property and buy the things that are renovating your property, we're talking about like electrical sockets and you know, CDFs and that type of thing. That stuff is expensive, and you can't have people just do that and be paying you to live in your house and then shove them out. I'm full disabled, and I'm on a voucher that was just now created in April, and they was kind of expecting me to have not an eviction on my record, because when I created it, I didn't have one.
Okay. So your testimony that all of your belongings are out of her home and that you are not.
Yes, ma'am.
You're not.
I never had any. I had a bag of clothing in her den. That was all I ever had in her. I never had belongings. I never had sent mail. My mother brought my mail over and left it in her door. She said I was having packages delivered to her house. That's not true. She went with my mother and picked up the mail and brought it back to her house and delivered it to me. So when she put there, I'm having packages delivered there, I wasn't.
Sir, please just answer my questions, okay?
Yes, ma'am. Yes,
All right.
ma'am.
So were you staying outside the home ever, spending the night outside the home?
No, ma'am. When she said that I slept in the car and was in the vehicle of the car, that was not sleeping in the car. I was connected to the Wi-Fi, and I was outside in her driveway, and she looked outside. I wasn't sleeping out there. I wasn't staying out in her driveway or none of that. I was just parked outside because I can connect to her Wi-Fi, and that was 1 or 2 times, and that was all. But prior to me actually coming in the house and staying,
So
I am full disabled, and
sir, you said that 4 times.
Yeah.
Do not need to repeat yourself. I'm listening to you, okay? Please,
yes, ma'am.
questions only. So you have no belongings.
Okay.
You're not staying
No.
at the property. Can you promise me that you will not go back on her property?
Yes.
Do you have a key to her property?
No.
Do you think that's correct?
Yeah, but I'm having the house from the future.
Okay, all right. Well, part of the thing that you have to prove is that he's staying there, and if his testimony under oath is that he's not staying there, then I need to dismiss this, okay?
That's fine.
Okay, but Mr. Carr, if you start showing up on the property again, then Miss Allen is within her rights to come back to this court and do this all over again. And actually, because this has been dismissed, and you have stated on the record under oath that you are not staying there and that you do not live there, you do not have belongings there, now the police can arrest you for trespass. Okay? So I want you to understand what will happen if you go back to the property. Do you understand that?
Yeah.
Okay. This case is dismissed.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir. Put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
No face there. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.